Tuesday meeting of the Green Mountain Care Board. I'm Alan Ramsey. We have a small but dedicated group of board members here today, a little smaller than usual. But nice to have you all, and we'll get started with, we'll start with approval of minutes. We have one set of minutes from Thursday, May 3rd, 2012.
Move to approve the minutes of Thursday, May 3rd, 2012.
Second.
All those in favor?
Aye.
Good. Thank you. Chair's report. Georgia, do we have anything from Anya that she would want to report to the community today?
The only thing is that our meeting on Thursday, we'll be hosting primary care doctors from around the state, so a topic the board's been interested in. So I think we got 4 or 5 folks who are going to come in and talk about what they're experiencing right now to help the board and inform the board.
Great. I think we get a good turnout for that. Any others?
No, thank you.
So today we have some guests from to discuss with us public participation of our regulatory processes. John Bailing and Shrinka Kerr and Lila from the Office of the Healthcare Ombudsman. How are you all going to work?
I guess I was going to go first.
Okay,
I'm
good.
John Bailing. I'll sit up
Welcome.
here.
Nice to have you.
Nice to see you. This is a really good outline that the Ombudsman put together. I don't have one for you, but I will send one. But I'm going to kind of use this as a framework and really give you the 30,000-foot view and try to respond to questions as best I can. I think that'd be the best use of my time. Just to give you a very general sense of my background, primarily I've been involved in environmental litigation for about 25 years. I came over to the department about 2 years ago from the Vermont Attorney General's office and then became the Director for Public Advocacy a year ago. Our primary focus at the Public Advocacy Division is representing the public interest of the state of Vermont. And what that means for our division, for our department, is to provide economically viable, environmentally sound, and reliable utility services to the state of Vermont. And all those things have to be balanced together when we represent the public interest. Our primary focus is on litigation before the Public Service Board, where we represent the interests of the state of Vermont. Utility rate cases are a big part of our practice. Utility generation siting, for example, wind projects, solar projects, things of that nature, and a whole host of other matters. We also handle telecommunications issues, gas issues, and our office is comprised of me as the public advocate. I have a full caseload in addition to managing the office, and I have 6 lawyers who work for me. We also appear in other fora, such as the Nuclear Regulatory Commission, Federal Energy Regulatory Commission, sometimes before the SEC, again, in utility matters relating to the state of Vermont and its public interest. I think probably the biggest challenge and something that you folks are going to be faced with is trying to define and consistently apply this concept of what is the public interest. Because what you'll find, what I find, is that there's a lot of competing interests. It's not as simple as it sometimes sounds. So just to give an example, I think historically, if you'd gone back 20, 25 years ago, and I should just note that 30 years ago, all there was the Public Service Board. And in most states, all you have is a Public Utility Commission. That's a very typical model. And there is usually some kind of internal advocate within that PUC, but oftentimes the consumer advocate is the Attorney General. That's a much more typical model nationally. About 30 years ago, the state of Vermont split out the advocacy role from the board role, the adjudicatory role from the advocate's role. And I think it's worked pretty well, and I think most people would tell you it's worked pretty well. I think people from all points of view would agree that it's been a good model. You tend to develop an expertise that's difficult to develop outside of this realm. It's a very complex area. There's a lot of arcane issues that really only utility lawyers and economists and analysts encounter. So it's nice to have a very specialized group handling these types of matters. Where I think things tend to get complex, as I mentioned, say 25 years ago, what you really probably would have focused on, what we would have really focused on is rates. What's it going to cost the ratepayer? That was the primary focus. If a utility wanted to do something and it was going to cost a lot of money, utilities make money by investing money. That's the model. And so there's something called gold plating, where a utility might invest a lot of money in something they don't really need to invest that much money in, they get a lot of return on their equity. And the public advocate was really there to watchdog that. Now that always had to be balanced against reliability. That was always kind of the tension. You don't want to be too parsimonious and not invest enough, then you're going to have utility outages. But you don't want to go so far as people are paying for stuff that's never going to be needed. And that model, I think, continued pretty consistently until, I want to say, not that I was here, but I've read enough of the cases, about 10 years ago, with the introduction of a lot of policies by the legislature in Vermont. And probably the most telling example would be renewable energy. Renewable energy costs more to produce. It just does. It's very, very cheap right now to produce electricity using shale gas. Extremely cheap. It's the cheapest it's been historically for I don't even know how long. A long, long time. 3 to 4 cents per kilowatt hour. Renewable energy goes upwards of 12 to 20 cents. It's much more expensive. And so if you'd put us back in time and said, well, what do you think, public advocate? We would have said, it's too much money. But remember I mentioned environmental. So one of the issues we need to think about is what's more environmentally sound. Do we want to keep burning fossil fuels, which is much cheaper, or rely on things where you don't introduce carbon into the atmosphere? And so there's this tension. But we also don't want to go too far in terms of how much money, frankly, people can make by producing renewable energy. So there's this kind of constant tension and battle, and it's very complex and interesting because you have folks who, you would typically think are allies in opposition. So it creates an interesting kind of dynamic, interesting tension. In terms of interface with the public, I just got off the phone before I came here. I get probably at least 10 calls a week from people with interest in anything you can imagine relating to utilities. We have our own consumer division. It's called CAPI, Consumer Affairs and Public Information Division. I am nominally in charge of them. They have somebody who's been doing this for 10 years, and she's great, and I don't manage her. She doesn't need me to manage her. I only have her come to me if something gets into kind of our realm. If it really is a legal dispute or they need a legal opinion, I have her come to me. But they take care of their own business. But over and above what they do, I get a lot of calls from folks. And often they'll ask these kinds of questions. If you're the public advocate, if you have the public, and they think to them the public means them, right? My interest is this. How come you're not representing me in this case? Well, I don't like this. I don't like this wind turbine. I don't like this solar panel. I don't like paying this much money. And it can be hard, and it can sound kind of maybe lawyerly to try to explain to them what it means. It doesn't just mean you. It means this guy, that guy. And it's a constant challenge. It just is to kind of tell people what it means to represent the public in these kinds of matters. The Consumer Affairs Division handles enormous numbers of consumer complaints for any kind of utility service. I would say mostly telecommunications and electricity. It usually has to do with billing disputes, service problems, and they do a great job of keeping it moving. They work in conjunction with the Attorney General's office, which has its own Consumer Affairs Division. Sometimes they'll send things over here. There's kind of a dual jurisdiction for a lot of things. But we tend to handle a lot of the day-to-day in and out, and they're very, very good at getting utilities to be reasonable. And there's a lot of rules that apply to the utilities, and oftentimes there's varying interpretations, and we have a very obviously pro-consumer approach and try to make sure people don't get the lights turned off or the heat turned off or whatever in the middle of the winter. So we have a vibrant role there. It's unusual that those kinds of things actually go so far as to involve lawyers. It does happen sometimes. What will happen procedurally is that they'll open an investigation. If something keeps happening, it's a pattern. You go to the board and you say, look, this keeps happening with these folks. The board is actually the regulator. We're just a party. That's the thing. I can't issue orders. I can go to the board and say, I need an order telling them to stop doing this. But my office has no enforcement. It's not like the EPA. I can't issue an enforcement order. I have to go to the board and get orders, get relief from the board. They're more like the court. Other issues, we deal with a great deal of legislation, particularly in the last few years. There's been, every year, much of what we do gets turned upside down and shaken up and moved all around, and there's a lot of legislative process involved. So we have folks who spend most of the last 4 months across the street, 12 hours a day, at least 5 days a week. And there's a telecommunications folks are over there. We have people who specialize in that kind of thing, and we'll introduce our own legislation. We work with all the stakeholders, and we try to work out, just like any kind of legislative process, we try to work it out so that it benefits the state. My office has people who are involved in the legislative process. We review the bills, we comment on the bills, we work with legislative counsel, so we do a lot of work legislatively as well. In terms of funding, we receive our funding through a tax imposed on utilities, so we're not funded through the general tax base, so we're off the budget line. Anything else to mention? We have a lot of reporting requirements. There's a number of statutes that require yearly reports from my department. Not so much my division as other divisions, but we are kind of in charge of making sure those things get done. We've got the calendars and remind people. I think, from a very broad perspective, that gives you a sense of what I do. And I'm happy to try to answer any questions you might have about how what I do might relate to some of the things you're going to be facing. Yeah.
Yes, Mike.
Thank you. John, thanks. Wondering what, if any, processes the department uses to kind of gather, information or data about defining the public interest, because you talked about what a challenge that is. So I'm just curious how the agency does that.
It really is a case-by-case analysis, honestly. An example I would give is in the area of wind. One of the big issues when you cite a wind project, and when we go to the board, there's a statute called 30 VSA Section 248. That's kind of our basic statute for any kind of siting. And you have to apply these criteria whenever you cite any kind of energy generation facility. And one of the criteria that comes up a lot for something like wind is aesthetics. Well, aesthetics is subjective, but you do hire experts and you have people provide opinions to you whether or not something is unduly adverse under state law. And it's a very fine, you have to really look at things very carefully. And so in one wind case, our experts said it was unduly adverse as to a certain number of folks who were close into the turbines. But the board has imposed another rule which says you can balance the societal benefits of the project on the impact. And because it was a relatively limited number of people who actually were unduly adversely affected in that particular situation, in essence, we ended up saying that it would not be unduly adverse under this test. So that's just one example of, it really is very case specific. There could be times when that you're not going to meet that test. If it adversely affected a lot more people, if the amount of power being generated wasn't that great in comparison to the number of people being affected. So it's very much a balancing test, and it's a close call and it's a tough call, and we got a lot of criticism for that one. We still do. So you have to make these pretty hard judgment calls on these things.
Are you required, by statute or rule or anything outside of the confines of a specific case to pursue any public engagement or public input process?
It depends. I mean, there are certain activities that we undertake that do. Just last year, we issued the Comprehensive Energy Plan, and that had a great deal of public process associated with it, which was required. Things come up periodically where there's a requirement. Most of the public process that we're involved with is required by statute with regard to the board. So whenever you have one of these projects, there's a great deal of public process. You have to have hearings, public hearings, which aren't technical hearings. They're not. No one's sworn in. It's just folks show up, they get to speak. It's all very much put out there. You want to be very transparent. So we are involved a lot with public process. And in my office, frankly, we try to be, the board has to be more reticent because they are a court. And so it can be very frustrating for folks to call there because they can't really tell them that much. So they send them to us, to me. And so, you know, I try very hard to send a lot of emails, I send a lot of information to folks just so they know exactly what's going on and get the information out to the public. I don't know if it's technically required, but it's just good. It's good government, and if you don't do it, you create a lot more problems by not being as transparent as possible, frankly.
Others?
I have a big question, but I think I'll wait till a little later and once we've heard more presentation. But I'm particularly interested in the enabling statute says to promote the development of citizens and consumer organizations. I'm wondering how you relate to the national organizations like Consumers Union.
It's a good question. You know, there are a couple of national organizations who do get involved in our work. AARP, for example, is a big ratepayer advocate. And so sometimes we're on the same side and sometimes we're opposed. It really kind of does depend on the issue. There are certain things that we are almost in lockstep with them on, and there's sometimes when we are, and it brings a good point up, you know, for low income, for example. I mean, the way you fund low income programs for electric consumers is by having other ratepayers pay for it. So that's a good example of the tension. I mean, how much is reasonable? How much relief do you want to give? How much of a burden do you want to pose on people who are moderate income? You know, so there is this sliding scale. Everyone agrees it's a great idea to help, you know, people out that can't afford it, but where do you place the burden? And there was a time when the department thought that really should be a statewide tax issue versus a rate paying issue. So, you know, even though I think we all kind of agree in concept on, you know, where we want to be, it's how we get there that we sometimes diverge.
Under the subject of independence, you know, how do you remain independent from the political winds?
You know, it's always a challenge. I work for a commissioner. She works for the governor. And, you know, to me, the way it works is the governor or the executive branch sets policy. And so, and when they run for office, they should state we're setting policy. And so, you know, the statute is the statute. Legislature also sets policy by passing a statute in terms of where we want to place emphasis, where we want to go. There is some policy that comes in, and it does somewhat vary. But I can tell you, for example, I've worked under 2 governors, even though I haven't been there very long. And you know, even though the big policy is the same, our approach to the cases doesn't really change. I mean, we have to take the cases as we see them. And so I've been pleased that no one ever comes and says, thou shalt. It's, you know, you have a sense, so here's where we would like to see things go, but you've got to put it through that process carefully and make sure it matches up to what the statute says, the rules say.
Just getting back to the history here, we have regulatory responsibilities and policy and advocacy. So this board has, you know, clearly its responsibilities, and we've heard from other states that have had control of whether it be all, you know, their state budget or all payer rate setting. And getting back to the history here, there was a time when the Division of Public Service, basically appeals went to the Attorney General's office, and then like 30 years ago things kind of started to change. Have all states changed it now so that all states have this separate advocacy within their public service?
No, we may be the only one. We're the only one that I'm familiar with. Certainly in New England, I know it's all PUCs, and that's very much the national model. And I couldn't tell you what the impetus was.
That's what I need to know, because I kind of look at the future of what we're going to have to do to make this reform process successful.
Yeah, I mean, I could tell you that one of the reasons and one of the things, if you go to conferences and you read the literature, one of the things that PUCs face that's very challenging is the concept of ex parte. Right. Because if somebody, you know, in-house is the advocate and the guy sitting right next to him is the judge, you know, that get a little hinky, you know. So I think there was a view like, let's keep them on different floors, you know, and then encourage them not to be too. And the board is very good about this. I mean, they really treat it very seriously. And I am incredibly tight-lipped. I won't talk about cases with the board. I just won't. you know. So I think there is some value to keeping a separation. Even if you have the best intentions, it can be really challenging to have both roles.
Any other questions?
I have one more.
Michael, good.
Is the department required to appear in every PSB docket, every, certificate of public good, every rate setting?
If you had asked me 6 months ago, I would have said yes. Well, we do appear in every docket, yes. We're a statutory party. There is one category that came up of late where we really just appear, and that's about it. Because what happened was the legislature assigned appeal of environmental permits associated with renewable energy projects to the board versus the environmental court. It's A&R's time. We'll enter an appearance. If anything happens that could in any way affect some of our criteria, we might weigh in. It just started, and I have a notice of appearance in, and I talk to A&R all the time, but it's like, there's nothing for us to do. It's an environmental appeal. It's not a utility matter. Other than that, yes, we are a statutory, us and A&R. And there's plenty of matters where A&R does the same thing. They'll enter notice of appearance, and they have nothing to do with it because it's not. It doesn't rise to the level that even any kind of doesn't get on the radar screen.
So you're the guy I call about cable?
Jim Porter.
Okay.
Solar panels.
Yeah.
I guess I don't understand where the public interest falls on that subject, meaning a town has a select board and a zoning regulation, but they don't have to abide by it.
Mm-hmm.
So who represents the public in that case?
That would be my office. I mean, some solar panels, if you're talking about individuals just in their yard, I mean, it really, at this point, is just an application process. I don't even see them. If it gets to the level where they actually have to get what's called a certificate, well, everyone has to get a certificate of public good, but if it rises to a level where you actually have a board process, then our office would represent the public in that matter.
But it seems like it's been taken from the municipality to be able to, for lack of a better word, regulate what's allowable in a town.
That is what 248 did.
And so, how do you deal with something like that?
I mean, we hear it, but it was a policy call, it was a legislative call. And, I can tell you, I used to practice in Massachusetts, and it works both ways. I mean, I understand that the principle, I believe, was to have consistent policy throughout the state. Versus for things like this, there was a judgment that the state as a whole wanted to promote these things, and that therefore it should be a statewide process versus a town-by-town process. And that was the legislature's call. It's been that way for a long time. But towns, we hear from them. We do. And citizens, we hear from them. They get frustrated. And things sometimes get cited in places where people just don't want them. And they come out and there's a process, and occasionally they're rejected. It doesn't happen very much, frankly.
I think it's a good example, though, of something if it's done from on high, and then, what is local control, and then how do people feel about that? And so I'm deeply interested in how you reconcile that. If your charge is to look out for the public interest, it's not to look out for the legislator's interest or the governor's interest. It should be, and if the people are represented by elected officials in their own towns, why wouldn't you side and fight with them?
Well, sometimes you do, but I think the concept is the public interest, from my perspective, is the public interest of the citizens of Vermont, not the citizens of Charlotte, not the citizens of, Lowell. It's
you got
the state.
close. You're really close.
Okay.
Yeah.
Okay, but I mean, it's the state as a whole.
Yeah.
And so you have to look at it. I mean, the criteria, for example, the aesthetics criteria does take into account the character of the surroundings. I mean, that's what you're looking at. If you're putting a solar farm in the middle of an industrial park, which I had one like that, I had one on the air base, Air National Guard. No one really complains. You put it in a field and there's a lot of people around it, well, then you are, in essence, looking at it from the town's perspective. You don't just divorce yourself and say it's just a solar farm. You got to look at where it is. Right. And your experts got to look at where it is and whether it fits in. So that to that extent, it is bringing in the individual or the community's concerns forward, but it's being done not by the town itself. It's being done by the state. And believe me, I hear you. I've heard from a lot of people exactly what you're expressing. People do get frustrated.
Does anyone see the humor in the fact that they're kind of the same size and shape as a billboard? Am I the only one? I mean, just a thought, I don't know. Guess no one thought of that.
It's been brought up. It's
Oh.
been brought up. It has been brought up. There's a lot of, and, yeah, it's a challenging proposition, and I think you're gonna just see more of it, honestly. I don't think it's going away anytime soon.
It's going away some places.
It does seem to be going away some places, but at least in Vermont, I can tell you from my office's perspective, it hasn't slowed down. We're still getting a lot of applications.
And what are you paying? Is it like 32 cents a kilowatt hour?
For solar, if it's standard offer contract, it's 27 cents. That's below
Probably why you're
2.2.
getting,
What's that?
it's probably why you're getting
That's why people are putting them in.
contestants to win.
Absolutely,
Yeah.
yeah. And that's the idea, is to make it economically viable.
Any other questions from the board? Thank you, John. If
All
you
right.
could stay around, we're going to hear from the...
Actually, I probably should get back, but I will send you something similar. Thank you for the outline. Thanks, nice meeting you.
Well, if you are going to leave, maybe I could ask
Yeah.
my other
Oh, yeah, you
question.
have another one, I'm sorry.
It's kind of a big question, and maybe Trinka will address it as well. And it's sort of stepping back from the details that are nicely laid out in Trinka's report to say that you and we are involved in a rather bold social experiment in many cases on many topics. In our case, we're implementing a law that's based on 14 principles that is more or less an outline. And it's a bold and visionary outline, but nonetheless has a lot of room for what I would call bold social experiments of an innovative sort. So normally in health or medicine, when this happens, one has an IRB or some kind of a process by which one looks at an experiment. In this case, we're embarking on things like pilot payment reform models. We don't know which one is going to be best in Vermont, maybe all three in the end or 10 forms of payment. But nonetheless, we're doing that in an experimental sense of we have a question, we have a process by which we're going to try to answer some questions, we're going to have outcome measures, and then some determination of whether or not we can go to scale with any of these three as an example. In thinking about representing the interests, we have, in a sense, people at the table to help design these pilots. But it is still a learning health system in the National Academy of Sciences IOM sense. So in thinking more about sort of the institutional ethics, I've been talking to some people like Arthur Kaplan from the University of Pennsylvania, Nancy Dubler, about the ethics in a sense of how we conduct our work writ large. And their point was that unlike an IRB, which would look at the experimental design, at the impact on individuals, in this case, transparency and communication between the interested parties is the way in which we, in a sense, fulfill our ethical duties to the state and to the society. Seems to me that you guys are a big part of that representation of people's interests. So I really was hoping that you could reflect with us on that question of we are embarking on this series of innovations which could be looked at as social experiments, and how, in addition to having a website and public hearings and listening sessions around the state, and you representing people at many of our deliberations, including our rate reviews and other parts of our deliberations, do you have any additional thoughts about how we might envision this particular aspect of our work?
I think, what you're describing is frankly pretty different than what I do. It just, there's already an established process for public participation in what I do. And there are pilots, but the pilots are in the context of a proceeding. For example, low income, that was done as a pilot project. And we would, make recommendations as to how best to try these things out. You don't just jump right in and have the entire state. It was a couple of utilities went first. And so within the confines of our process, it's already pretty well laid out. You're talking about really something honestly a little bit more radical than what we're talking. I mean, this has been around for a long time. But what I've been doing has been around a long time. So when you move things, there's already kind of a built-in process, whereas you're kind of making up the process.
Well, I
now.
should say, I mean, for example, the 3 pilots, we didn't invent them. They're ones that are happening in other states,
Right.
including in Vermont. It's just that we're trying them out in the context of implementing a law.
Yeah.
That's what's different.
Yeah, yeah, and I mean, that happens with us as well. I mean, we do, low income went from being, not to bore you with too much information, but it began with the proceeding. It was imposed via board order, and then after the board order, the legislature actually passed a law which broadened it. So it often will start, via board process and then go to legislature. So they broaden that aspect. And so now there are low-income requirements in state law versus just pursuant to a board order. And so it often grows from an individual case to a broader policy issue. And, what happens is that advocates go to legislature and they say, look, what's happening here, this is good. Well, why don't we broaden this and expand upon it? But we've already, in essence, participated in the small, petri dish. And then once it gets bigger, we have some experience and some background in terms of how to implement it going forward. I hope that answered your question.
Yeah, that's the beginning. And Trinka, I hope you'll comment on that as well. Thank you.
Okay.
Thank you.
Thanks a lot.
Thank you.
Trinka and Lila, you want to come up and kind of walk us through this presentation document? Thank you for sending that.
Yeah, it's kind of funny to have someone else use the outline first.
Show some good outline.
It's a public outline.
Yeah.
Yeah, well, it is now,
Okay.
yeah. So, good afternoon. I'm Trinka Kerr. I'm the State Healthcare Ombudsman. And this is Lila Richardson, who's one of the staff attorneys in our office. And I'm going to give the background and discuss our responsibilities. And Lila's going to talk more specifically about the rate review obligations. That's what she's mostly working on these days. So I was going to start with my background, and didn't know how much of my life story you wanted to hear, but I'll skip over the fun parts like when I was a ski bum and go right to when I moved to Vermont in 1980 and started working at Vermont Legal Aid, where I've worked ever since. I started out as a poverty law attorney, and in that capacity worked with people who are on public benefits, including Medicaid and Medicare. So that was my healthcare exposure at the time. I worked on a lot of different kinds of systemic issues, both through the courts and with legislative and administrative advocacy, including, as a side note, working for quite a few years with Robin Lunge on welfare reform in the 90s in the State House and with the administration. And that was sort of a little mini chance at reform, healthcare reform. I thought that was complicated, and healthcare reform is way more complicated than welfare reform was back then. So after working for 20 years as a poverty law attorney, I started working as a staff attorney in the Office of Healthcare Ombudsman. And that was when Donna Sutton-Fay was the ombudsman, who I think spoke to you a week or so ago. She works at the Campaign for Healthcare Security now. And then after she left, I became the director of the State Healthcare Ombudsman. So by way of some background about our office, the idea of a state healthcare ombudsman was created by enabling legislation, which I believe you got a copy of, in 1998. It was modeled on a national long-term care ombudsman program, which is an ombudsman that works with nursing homes and people in long-term care. In Vermont, the long-term care ombudsman also is within Vermont Legal Aid, and we coordinate with that office. The state contracted with Vermont Legal Aid in 1999, and we began operating as the State Healthcare Ombudsman. Vermont Legal Aid is a nonprofit statewide law firm. The enabling legislation specifically set us up to be independent and not part of state government. That was felt to be extremely important. That we would have no conflicts of interest, which are set out in the statute, and that we would have basically really a dual role. One is to help individual consumers with different kinds of problems, and another to speak as a voice for consumers with policymakers. And unlike these kinds of offices in other parts of the country, we deal with all kinds of health insurance. So not just commercial plans, but all the state Medicaid programs and the federal programs, even like TRICARE and those kinds of things. My office consists of me as the director and 2 staff attorneys, Lila, who does rate review work and some of the tasks from Act 48, and another new staff attorney who's helping to supervise the advocates who man the hotline in my office. We're located in Burlington, except for Lila, who's here in Montpelier. And the hotline is, we have 5 healthcare advocates, or basically paralegals, who answer that and directly assist consumers. In terms of our funding and who we report to, we work primarily with 2 state agencies, the Department of Vermont Health Access, or DEVA, and we have a core grant with them, and then the Department of Financial Regulation, and we have a core grant with them. Since the Affordable Care Act was passed, we've gotten additional funding that gets funneled through those 2 agencies. We now have a grant through DEVA to help with work related to the exchange, and we have the rate review money under the Affordable Care Act that's coming through FinReg. We also got a Consumer Assistance Program grant under the ACA through BISCA at the time, and we're in the process of applying for another small one right now. And we're hoping that there's going to be more federal funding for consumer assistance programs, but right now that's still unclear because we don't really know what Congress is going to do. So in terms of discussing our responsibilities, a huge part of what we do is helping individual consumers through our hotline. Last calendar year, we had over 3,200 cases. The previous state fiscal year, we had a bump up because the state had some problems with its eligibility system, and we had 3,500 cases that year. The way we organize the data that we collect is based on the insurance status of the person who calls or has the problem, and these are roughly the percentages of the kinds of calls we get. About 40% of people who calls are on state programs, about 20% are on commercial plans, about 10% are on Medicare, about 10% are uninsured, and about 20% we don't actually know because it's either not relevant to the case or the person is clueless as to what they have and it doesn't really matter. We're trying to get that piece of information more consistently from people so we can see who's on commercial plans when they call, but that's relatively new. So we report quarterly to FinReg and to DEVA, and we have an annual report that's posted on our website. We advise and assist consumers with a variety, like any kind of problem related to healthcare or health insurance. And I gave you a little bit of the breakdown of the types of calls. About 30% are access calls where people are trying to get access to something. About 30% are related to eligibility for government programs, and about 15% are related to billing. A lot of our calls are related to appeals or complaints. We provide a lot of consumer education to people around what their rights and responsibilities are, and do a lot of explaining about how health insurance works generally. We also deal with all kinds of other problems like confidentiality and HIPAA, access to medical records, provider complaints. Well, we get a lot of very weird questions that we try to deal with. Then the other piece of what we do is policy work, which is in part driven by the kinds of calls we're getting from people. And I kind of tracked the enabling legislation on that, but we provide feedback that we hear from consumers, and we try to influence policy both by working in the legislature and working with the administration. We testified a number of times on H559 as it worked through the legislature this session. We also analyze and look at federal and state laws, regulations. We comment on lots of different regulations, and Act 48 now requires us to also comment on regulations that you promulgate. Act 48 also requires us to represent the interests of patients and consumers and make suggestions to you regarding consumer protections. And we're also supposed to facilitate public comment on the laws and regulations, and we recently had a chance to do that where we had quite a few seniors who were having problems with their Medicare savings programs, and we asked the legislature to look at that, and we helped quite a few seniors contact their legislators and speak to them about the problems they were facing with that. We've been very involved over the years in Medicaid policy. In particular, right now, I'm involved in the dual eligible stakeholder group, which has had an excruciating number of meetings over the last 8 months. Also the Medicaid Advisory Board, which is going to merge with the Exchange Advisory Board. A lot of different legislative committees decide that we should be on various work groups and task forces, and so right now we're on the Pain and Palliative Care Task Force, the Surrogate Decision-Making Task Force. Then Act 48 has us being involved in payment reform, and H559 has us involved in the pilot projects, commenting on that. Under Act 48, we're also going to be specifically helping consumers with problems with the exchange or with navigators, and their navigators and the exchange are required to refer people with problems to us. And we're also have been involved in the Certificate of Need process, where we're authorized but not required to participate as an interested party. We've only done that a few times where we've actually asked to be an interested party, although I get all the filings and I do try to look at all of them, and to the extent I feel like there's something we could do or we ought to speak up about, we try to do that. And H559 added the right for us to sue for violations of CONs on behalf of consumers. And H559 also has a section on working with FinReg and DEVA to try to figure out the right balance for how to represent the public as healthcare reform goes forward, because I know the legislature had some questions really about how this was being set up. So obviously we'll be part of that discussion. And I was going to have Lila talk a little bit about the rate review work that she's been doing, and then I guess we should talk about more specific questions if you want to talk about the model or how to deal with making sure the public's interests do get represented. You want to go, Lila?
Okay.
Unless you have questions for me
Yeah, I was
before
gonna
we
say,
switch.
Well, we can,
You
Lila,
wanna-
why don't you
Yeah,
give
okay.
us
I'll
your
do-
report, and then
I'll
we'll
do-
kind of open it up. Yeah.
Just by way of background, I actually have worked for Vermont Legal Aid for many years, just as Trinka has. I moved to Vermont in the late 70s after I graduated from law school, and I've been here ever since, except for about 3 years when I lived in Germany. And I've worked with 3 different projects at Legal Aid. First with the Senior Citizens Law Project, then with the Disability Law Project, and most recently with the Healthcare Ombudsman Project. And in some of those years I was working part-time for one project and part-time for another. But that's sort of the basic background of the areas where I specialized. And really, as I was working in the Seniors Project and with the Disability Law Project, I ended up doing a great deal of health care work, just because that's one of the main issues that comes up when you're dealing with seniors and with people with disabilities. For about 14 years between working with the Disability Law Project and with the Healthcare Ombudsman Project, I spent a lot of time during the legislative session doing advocacy work there. And I guess I just mentioned sort of parenthetically that one of the bills that we worked on in the late 90s was the bill that actually started the Office of Healthcare Ombudsman. And at the time, what I was actually representing the Vermont Coalition for Disability Rights, and worked with the Committee of Vermont Elders and a number of other groups where people felt that there wasn't a good enough focus of attention on health care, and that everybody thought that they were important issues, but nobody had time to focus on them. So we thought, well, we'll just figure out how to get a health care advocate. And that was so the beginning of the HCO. Interestingly enough, we thought we were just creating this policy group, and the legislature felt very strongly about the individual advocacy that Trinka was describing, and they made that a big focus as well. And I think in hindsight it was a wise combination of policy work with individual work. But we also thought, wait a minute, we were trying to find somebody else to do healthcare advocacy, and ended up with this combination. And as Trinka mentioned, I currently been starting to focus on the rate review work for the board through a grant that we have with the Department of Financial Regulation. And we signed that contract March 12th, but you probably noticed I was sort of hanging around before that and tried to get some background because the contract was in the works longer than that, starting when the board began to meet. Just one small piece of personal information. I mentioned that I lived in Germany for 3 years and actually had experience with another healthcare system when we lived in Germany, because my husband was working at a German university and we were getting healthcare through a very different, and I would submit, saner system than we have in this country. So, and I had actually quite a lot of interaction with the system at that point because our older son was born while we were in Germany. So we had visits for me, visits for our son, and spent a lot of time with midwives and people in the German system. So have a little bit of perspective on a different way of doing things through that experience. I don't want to, I know you all have spent a lot of time talking about rate review, so I don't want to, repeat things that you already know. There's really nothing explicit in Act 48 or H559 about the healthcare ombudsman role on rate review versus other functions, but there's this general section that Trinker referred to where the HCO was asked to advise the board regarding policies, procedures, and rules established under Act 48. And rate review is obviously a big one, and one of the first big ones that you're working on. So rate review has been the focus of this grant that we have with FinReg. I think, you've all talked about the fact that rate review isn't in isolation and that it's related to many of the other topics that you're working on, projects that you're working on, and very obvious tie-in with hospital budgets, with certificate of need, with payment reform. All of those things, as they start evolving, will, we all hope, help to contain costs and bring the cost of healthcare and of healthcare coverage down. So we see those as really very much linked. I guess one other area I haven't heard people talk about that much, but I would submit is also related to rate review, is the work you'll do around benefit design, because rate review really just focuses on premiums, and there are a lot of ways where what's affordable for people, what works for people in terms of healthcare coverage is also very much affected by cost sharing and the richness of a benefit package that people have, what things are covered versus what people pay out of pocket, and again, what the degree of cost sharing is. So I think as some of the design work happens, it will have an effect on rate review, and it's all very much connected, at least in my thinking. Short term, as you all know, you've started to get some of the rate review cases that were filed after the first of the year with FinReg. And I think you all know you have two cases that have actually come to the board, one you decided, one you're about to decide under this very accelerated time frame that's currently in effect. Right now there are 4 more that are pending, in the sense that the work at FinReg has been deemed complete, which means the actuary has finished talking back and forth with the plan, and then the commissioner will be working on a recommended decision to the board based on all the information that's already there. And so at this point, your website, has given those cases docket numbers as well and put them up as pending in sort of a different sense. At the present time, at least if the FinReg website is up to date this morning, there are 7 more cases that are pending at that level before, where they're still in the process of gathering information. So you have those to look forward to as well. And then there will be more filings for the next quarter, and on and on. Then the ones that you haven't seen to make its way to the board yet are basically filings from MVP, and there's one long-term care policy, which is still under the board's purview until H559 is signed, and then that will change. So I think we're all working our way through the new process, and this new two-tiered process, which I think has, it's not just adding a new layer with the board, but it's also changing the way that FinReg handles the cases. And I think one of the things that's going to be interesting to see, and that is already starting to evolve, is that decisions that were made before weren't really discussed in detail. They weren't articulated analysis by FINREG of what was going on when it approved or disapproved a rate filing, or when it sort of negotiated with the carrier and the carrier ended up doing an amended filing. That process didn't really have formal decisions, and now you're starting to see you get recommended decisions, and then you're creating your own body of decisions. So I think it's interesting at both those levels, and I'm sure it will evolve over time. I'm sure it comes to it's no surprise to you that the current timeline is really tight at the board level, and I think it's too bad that it started out with that time frame, but hopefully that will improve soon when you get at least 30 days instead of the 10 working days you currently have. We're all trying to figure out how the process of the contested hearing works, and I appreciate the fact that the board is committed to thinking about that and talking about that before getting started with the rulemaking process, because I think that's really wise, and that will be very helpful to everybody to sort of talk over what's been going on in the meantime. And then, as I said, there are all these other pieces of what the board is doing that will feed into the rate review process, and as you start doing certificate of need cases, that will have an effect on costs of the system. We've already made some interesting steps on hospital budgets that are I think going to affect cost containment in general. I know that there are discussions with the carriers about trying to sort of streamline the rate review process, which I think will be helpful, so that there aren't quite so many filings a year and it's a little more predictable for everyone as to when these things come through. I think that as I start looking ahead to 2013, just as things have started to quiet down probably and to get more routinized, I think there will be another burst of activity because of all the changes that are required with the exchange starting up. There'll have to be a lot of new products developed, and rates will it will be harder probably to judge exactly how rates will work, because the product design will be somewhat different than what people are currently used to. So, there'll be, for the next couple of years, there'll be quite a few series of changes and a lot of activity on the whole rate review front. I think everybody has been spending some time thinking about other models, which is good, other ways of maybe looking at rate review. I thought the presentation from about the system in Rhode Island was really very interesting, and we would certainly be interested in talking more with the board about how to work the system that looked more like that, if that makes sense in the future. One other thing that we are supposed to do that's part of the rate review grant is to provide consumer support to people who are interested in participating in the rate review process, which is a piece of what Karen was asking about, the broader public participation. And that's actually pretty challenging to figure out how to make people aware of the changes of what's going on just in terms of FINREG and the board, the Affordable Care Act, all the different things that are happening, and how they can usefully be involved other than to say, I don't like my rate going up, which is an important message to give people, and I think it's true, but it's helpful if they have a little bit, a little more information than that, and if they can provide comments to FINREG and to you that are, if possible, a little more nuanced than that. I think There's a lot of work to be done in that area because it's really complex. I've worked some with other advocacy groups, like the Workers Center and VPIRG and the Campaign for Healthcare Security, really mostly around the Catamount products, to make sure that they're aware of the filings and the process and that people know how to make comments if they're interested. I think that it is still all very new, and there's a lot of work that could and should be done really to make at least the websites, which I've been sort of concentrating on, work better. Both websites, both FinReg, and the board, and the general healthcare reform website of the state, so that people understand the context and understand the whole process and how they fit into it. One thing that the board decided to do with the regulations that I think will be interesting is to have these 2 general meetings on the rate review process for the public. We talked a little bit about that at a preliminary level with Mike and with George and Judy, and I think people are thinking that maybe the first one of those would be in the fall, and I think that will be an interesting time to try to get out information about how rate reviews work, how all these other initiatives that the board is working on can affect rates, how people can become involved in a way that makes sense to them. So, yeah, we'll look forward to working with you on that. I guess the final thing is we do get all these individual consumer complaints, and we're trying to track the people who call with issues about affordability, about whether their rates going up, and make sure that they understand something about how products are possibly subject to their comments, their input, and give them a chance to comment when they're interested in doing that, and either in the public process or in the individual rate filings. So those are basically the things I've been working on, and there's a lot of tie-in with the other things that Trinka's discussed. As I said, they're all there are a lot of moving pieces, and one affects the other. So we'll continue to work on all of those, and hope that you come to us and to me if you think there are other ways that we can be helpful.
No, thank you. Questions, comments from the board? I'm interested in this complaint process and you track them, you got your percentages, and that's good. And how would a provider complaint go to you versus like the medical practice board, or if you had people say, I called the board and they didn't want to deal with this?
No, usually people don't know about the medical practice board, and they call us, and the kinds of problems, people call us about all kinds of problems.
I can imagine.
With providers, yeah. And so some of the time it's, you should try to talk to your provider again. I bet that wasn't what he or she really meant, or whatever. So, and if people just really want to complain, we tell them about the complaint process, like at the hospital, or how to file a complaint with the medical practice board.
Yeah. Would it ever get down to the kind of granularity of, my employer could only offer me a deductible plan of $4,000, and I can't get almost anything done that I really need to have done and that's kind of an access issue.
Yeah, we hear that all the time.
Okay.
All the time. And we started hearing that more a few years ago, and we started actually trying to track it a little bit more, and that the complaints about affordability have steadily gone up, and a lot of it's related to high deductible plans, and some of it's related to other forms of cost sharing, co-pays, co-insurance,
And that was partly what I was trying to get at when I said I think benefit design in terms of cost sharing and what's covered, affect
Yeah,
people's experience a great deal. It's not just how much they pay for the premium, it's whether they have a deductible and what the deductible's for. And I think, I don't know, a lot of emphasis is being put on preventive care and primary care, which is important, but the people who are really sick, who have really significant health care needs and who have high deductibles, have a very, very difficult time.
Yeah. Another area of complaint that we hear about is people complaining about utilization management techniques, like, oh, my insurance company won't cover this medication. They say I have to do this other medication first. So we do a fair amount of education around that, and then explaining that can be appealed, that, there's ways that you might be able to get a different medication or a different treatment. And we get a lot of complaints about that kind of thing too. Prior authorizations, I don't know why, my doctor has to do this, my doctor doesn't want to do this.
I was going to say, I think prior authorization is a real problem where the patient and the provider are both very, very frustrated and not always clear on what the process is, and it varies from carrier to carrier and system to system, which is difficult for everybody because you're not sure if you have the right formulary, if you have the right prior authorization form.
Do you ever get any kind of comment about the Green Mountain Care Board or about healthcare reform when you get these calls? Like, well, I heard that they were going to have some control over premium rate increases, and that maybe they can do away with these ridiculous administrative costs. Do you ever hear that?
No.
No.
I don't think the people that call us that we're hearing from have a pretty limited understanding of what healthcare reform what's happening. Because it gets mixed up with the federal healthcare reform and the exchange, and then, single payer, and they just want to know, why can't I get this medication?
And I think
they're done here.
When I was doing cases, one of the times that sort of healthcare reform came up as a topic was in the kind of case where people have fallen through the cracks of the current system, which we're acutely aware of because, those are people who tend to make their way there. And then there are people who are sometimes paying exorbitant rates relative to their income for a policy, or they have these high deductible plans and high cost sharing, and there's no way for them to switch over under the current rules for the public programs to get covered by them. And they feel it's really unfair, and they're right. They're in a bad situation, and sometimes you say, well, things will change when if the exchange becomes available, it will change in this way, and can talk long term to them about healthcare reform in Vermont, but usually they're very focused on their particular really difficult situation, and you're telling them, yes, you're one of the people who's falling through the cracks. And
that's a cost driver, just a huge cost driver.
Mm-hmm.
We know it. So, other questions?
So thank you again for all of your work with us. So putting on my old hat as someone who actually sat in pretty much close to your shoes when I was doing nonprofit law work for a healthcare firm in Boston, where we did policy and direct client representation. And one of the things that I found very challenging was you're always here, you hear the kind of critical casework, but then you have to balance that with the policy choices. And as you become steeped in a topic such as rate review, and you're more knowledgeable, things that seem to be unreasonable to certain individuals are not as unreasonable to you as their advocate, because you're seeing a larger swath.
Yeah.
And so, similar to how we asked John earlier, how do you balance the consumer interests in different policy recommendations that you make?
Well, I think we try to take as broad a view as we can, try to help the most people that we can, but also, I mean, a lot of times it's like on specific issues which seem relatively clear. Plus, I feel like we're advocates for consumers and patients, and other parts of state government are looking out for the state's fiscal health and the carrier's fiscal health. And we're pushing for what the consumers and the patients need. You know what I mean? So in some ways, we can look at it a little bit narrower, because although we do know what's the interests of all sides and can see all that, but I feel like we need to still push for what consumers want and what consumers need. And the other forces, as an advocate, that's what we do, and that the other forces will have to push back and say, well, we have to make sure the carriers are solvent and whatever, that kind of thing. So that's one angle looking at. I mean, I think you can look at it from all through different lenses, but that's the predominant lens that we look through.
Well, just to come back to the big question for a second, I was wondering if there's any state anywhere who does almost more of a report card of a bigger picture of trends over time and how the public feel they are being represented, or how adequately are they. I mean, certainly to have a tally of the number of calls and the types of complaints, that's very, very helpful data points. But is there any way to look at what difference has, in a sense, in the larger sense, especially as we embark on a new law, the public engagement piece?
Yeah, I mean, nationally, up until the Affordable Care Act had the Consumer Assistance Program piece to it, there weren't very many organizations like ours in other states to look at in terms of models. There were really only a few, and not all states created consumer assistance programs as a result of the ACA. I think 30-something states got that money, and 2 states turned it back. But so it's not like the long-term care ombudsman program there's a long-term care ombudsman program in every state because of federal legislation. For a state ombudsman, healthcare ombudsman program, there's different models all over the country. A lot of times they're within attorney general offices, sometimes they're within the Department of Insurance. Some other places are in nonprofits like ours. There are several different models. I think, here in Vermont, there was a feeling that it was really important to have it be separate from government. And, I've had some conversations with Steve Kimball about that, and, I think he supports that there be a separate independent ombudsman. Now, how many tasks the ombudsman should be taking on is an open question, I think. And what kinds of things should the Department of Financial Regulation really be doing as a regulator and as the state? So I think that's going to be an ongoing conversation, because, the Department of Financial Regulation looks out for consumers too.
Mm-hmm. So maybe I can just ask another question to kind of get at this.
Okay.
When there were all the conversions going on with hospitals going from non-profit to for-profit, and the state of California had a bunch of lawsuits, and I guess others did as well, to be sure that there was some public good that came of those conversions, because so much money was at play. So that, again, was an attempt to look out for the public writ large. And now, as I understand it, the IRS is quite interested in community benefit of hospitals in regards to their IRS status. So again, these are more from the population health perspective, not so much individuals as you've been reporting to us. Is there any thinking in the Ombudsman's office, or has there been discussion as Act 48 was coming about of this type of thinking? Because our responsibilities include things like a unified health budget and a workforce plan. These are big picture things. So in trying to think about the public engagement piece, I've been doing a lot of thinking of how do we look at it from a number of levels, including this larger population-based level. So those were a couple of questions that occurred to me around community benefit and
Yeah, I
I know like GW is doing a project on community budget, community benefit, with case
Yeah.
studies around the nation. Sarah Rosenbaum and I know Maureen Burns is working on that. But I just wondered if any of that stuff is happening here, and you're thinking, or are
we haven't really looked at that. For us to really get involved in sort of bigger policy work like that, we probably need more staff. You know, so that's a resource issue. But you know, when we do work, we have worked with national organizations on occasion, but like that particular issue, we haven't really looked into, for instance, but.
I participated in a national conference on the concept of community benefit, I don't know, last week or the week before. I'm sort of losing track now when it was, and have some materials on it. I think probably the hospitals here would say, one of the things that Vermont is doing that's really different is the whole Blueprint initiative, which is, has, I think from the hospital's point of view, involved them a lot in getting involved in ways that hospitals haven't been in other parts of the country. So, I think that's sort of an ongoing effort and possibly building on that model and figuring out how hospitals could be more of a resource through that kind of work might be something that would work well in Vermont.
I'd be interested in seeing those materials from your call, who sponsored it and what they put together, if you can share them.
Was Community Catalyst convened it, I believe, but I think
Karen,
it's all on the,
I have a friend who's actually lead on this project at Community Catalyst. I can also connect you with her.
Great.
Yeah, and I'm sure they would be available, make somebody available to present to the board.
I'm sure they'd love to,
They would be very happy. I think you probably all know that Vermont is being closely watched by a lot of people, and there's a lot of excitement about, what the state is doing, what the board is thinking about and working on, and I'm sure there are, many national organizations where people would be very interested in presenting it, and I get invited to participate in conference calls. How often? I mean, we get
every week.
Constant emails, and we try to do the ones that are most relevant. But there are a lot of people thinking about some of these same issues, and as I said, they see Vermont as really pushing the envelope on a lot of things that they're excited about. So I'm sure that the people would be very happy to make a connection and present to you. But I can tell you, I can get you that information.
Thank you.
Well, thank you.
Thank you.
And
Thanks.
Lila, thank you for your diligence in attending our board meeting before the rate review came up. Asking good questions, that's great.
Thank you.
Thank you.
Do they have questions?
Well, we have a new business. Is there any new business?
There's no new business.
So we can open it up for public comment. Any comments, questions from the attendees?